remind you that you need to turn off your phones. Good morning, everybody. I'm glad to see you here for Nolan Atkinson's incredibly important presentation today on what's happening with civil rights under the Trump regime, the impact of the Trump administration's executive orders on racial equality. Those of you who come to Village College regularly, I'd like to point out to you that what Susie's doing and what I'm doing is called room hosting. So when Charlie Day sends out the invitation in the winter for the winter syllabus, asking for volunteers to come do this, I hope those of you who come regularly will consider doing it. It's one of the easiest jobs in the world. You hold on to a mic and watch for people's hands to go up. You make sure that if we're getting to the point where we're on overflow and the seating is getting to be a little bit dangerous for people who can't walk well, we shut the doors and put up a sign that says, class is full. And because of Ed Chidoba, it doesn't mean all is lost. You can go home and watch it on your computer by accessing YouTube. Okay, that's enough out of me. Nolan, take it away.
Good morning, everyone. This morning, we're going to talk about the impact of the Trump administration's executive orders on racial justice. Since Inauguration Day of this year, there have been a series of executive orders from the White House that have had a major impact on African Americans. We are going to take an objective look at some of those executive orders and give our thoughts on their impact on racial justice in this country. What are our objectives this morning? First, we're going to list the significant markers of racial injustice in American history impacting African Americans. Understanding the history of what African Americans have endured in this country is a condition precedent to assessing the impact of the recent executive orders and their impact on racial justice. So after looking at our history, we're next going to review pathways that the country has taken towards equality between the races. Next, we will then assess 5 executive orders issued by the Trump administration after January 20th of this year. We hope to identify the likely impact of those executive orders on the country's racial progress, and then hypothesize what the future holds for racial justice. Excuse me, my fault. First, though, we've got to do some definitions. And we're going to look at some terms that are used all the time, and we need to sort of come up with what they mean. Affirmative action is something you hear about all the time. Some people like it, some people don't. We're going to talk about it from a definitional point of view. What is an executive order? Is it law? Is it something else? We'll try and define that. What is DEI? It's almost a bad word in some settings, so we need to try and come up with what diversity, equity, and inclusion is. And finally, we're going to give our thoughts on racial justice. They may differ from yours. We're open to hear everyone's view at the end of the program. Affirmative action, the ordinary definition right out of the dictionary, the practice of favoring individuals belonging to groups regarded as disadvantaged or subject to discrimination. That's the dictionary definition. Also, there is racial affirmative action, which means something a little bit more. I have taken the definition of Randall Kennedy, a professor at Harvard Law School, who has written lots of books on race, and I'm going to read that to you. It is a continuation and intensification of an egalitarian and democratic impulse in American race relations has been gathering momentum, albeit fitfully and with dramatic reversals, since at least the Civil War. Racial affirmative action partially redresses debilitating social wrongs. I might add that the definition of racial affirmative action is not the definition that the Supreme Court has adopted. Executive order, what is it? They're directives issued by the president announcing the administration's policy, priorities, and instructing federal agencies to exercise their authority consistent with those priorities. Executive orders are not acts of Congress. They are strictly what the president plans to do. They don't bind actors outside of the federal government, but they might persuade actors outside of the federal government to follow what the president wants. DEI. I found this from an article about CNN, interviews of industry experts. Diversity. Embracing the differences everyone brings to the table. Looking around this room, it's clear we've got diversity right here in this room. Males, females, whites, blacks, different religions, genders. We've got everything in this room. So we've got diversity here. Second, equity. Equity is a little harder, and it's because everyone has their definition of what is fair, and everyone has a definition of equal. But basically what equity means is treating everyone fairly and providing equal opportunities. Finally, inclusion. Respecting everyone's voice and creating a culture in which people from all backgrounds feel encouraged. That means anyone who's in the back of the room is encouraged to express their ideas and their perspectives. Racial justice. I borrowed from Professor Kennedy this definition because I like it, and I think it is something that we should all aspire to. We proclaim loudly our goal to create a multiracial democracy, freed of the powerful pull of pigmentocracy and all other illegitimate social hierarchies. A society that enables the flourishing of descendants of slaves and slave owners, victims of conquest and conquerors, undocumented and documented immigrants, and people of all faiths and genders and sexual orientations. This is like Martin Luther King's "I Have a Dream" speech. It's a dream for racial justice. And that is where at least I stand on that definition. So, what are the markers of racial injustice? We're going to take a look at history for a moment. We've got to talk about what those markers are. 1, slavery. 2, black codes. How many in the room don't know what a black code is? Well, we're going to catch up on the black codes. Threats and violence, Plessy versus Ferguson, and Jim Crow laws. First, slavery. We all really know what it is, but it is, with emphasis, the forced enslavement of people as property who could be bought or sold. Slavery is a part of the very fabric of this nation. It is embedded in the Constitution of the United States. In 1789, they were having a fight on how slaves should be counted. Could they have a representative in Congress for slaves or not have a representative for Congress? And they came up with the count should be determined by adding the whole number of free persons, that's white people, including those bound to service for a term of years, that's indentured servants, and excluding Indians not taxed, 3/5 of all other persons. That's in Article 1, Section 2 of the original Constitution. So those who were of color, African Americans primarily, were 3/5 of what everyone else was. The black codes, these were enacted by the southern states immediately after the Civil War to severely restrict the freedom of those newly emancipated. They were local and state laws that detailed when, where, and how enslaved people could work and for how much compensation. The codes appeared as a legal way to put black citizens into indentured servitude, to take voting rights away, to control where they lived and how they traveled. One example of the black codes was that you could be convicted in some jurisdictions for disorderly conduct. And what was your infraction? You didn't have a job. And if you didn't have a job, you could go to jail for some period of time and so on. That's what the black codes were. They were done away after the Civil War, but they were around for a couple of years after it. Threats of violence. The southern states built a de facto system of threats, violence, and lynching against African Americans from the end of the Civil War to the mid-20th century. Violence was the law of the day. The biggest example was the Ku Klux Klan. Plessy versus Ferguson, 1896. There, the Supreme Court announced the separate but equal doctrine which upheld the constitutionality of racial segregation laws. What that meant was that there was a lawful basis for the nation to have segregation for the next 60 years. Finally, the Jim Crow laws, collection of the state and local statutes that legalized racial segregation. The laws existed for about 100 years, from the post-Civil War era until 1968, were meant to marginalize African Americans by denying them the right to vote, hold jobs, get an education, or other opportunities. Those who attempted to defy Jim Crow laws often faced arrest, fines, jail sentences, violence, and death. Now let's flip the page and look at various pathways that the nation has taken for equality or towards equality. And there I'm going to talk about the Freedmen's Bureau, the federal enactments, acts of Congress, executive orders, presidential executive orders, and federal jurisprudence. How many of you don't know about the Freedmen's Bureau? Okay. The Freedmen's Bureau was an act of Congress passed in 1865, which was designed to assist former slaves. You know, at the end of the Civil War, the Northern troops went home. They went back up north, and they were just there with the enemies. Abraham Lincoln had been shot. So what was to happen? First, they hoped to just basically assist former slaves through the Reconstruction period. There was an attempt to establish schools, provide food, and to distribute confiscated property to the freedmen. Some of you may have heard somewhere in your lifetime, 40 acres and a mule. That's what African Americans were supposed to get under this. Unfortunately, Andrew Johnson, who took over after Lincoln had been shot, was not in favor of that, and he slowed the whole process of what the Freedmen's Bureau could do. They were able to enroll former slaves into public schools, help start a system of higher education for the Negro, and finally, and most importantly, they provided a federal presence in the South following the Civil War. Okay. I just did that wrong. Let me go back. After the Freedmen's Bureau, there were acts of Congress which took place. First, there was Civil Rights Act of 1866, and that was the one which declared that all people born in the United States were citizens, regardless of race, and were entitled to the same rights. Then we have the 14th Amendment, which came 2 years later. All persons born in the United States were citizens. No state shall enforce any law which shall abridge the privileges or immunities of citizens of the U.S., and no state shall deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. Obviously, the first bullet about the Act of 1866 was aimed to protect the rights of freed slaves. The 14th Amendment is self-explanatory as to what it was to do. I put under the 14th Amendment in bold, nor deny any person, you can see it, within its jurisdiction, the equal protection of laws. That clause has become very important as one of the bases for the Trump administration's executive orders. So I will come back to that. Lastly, most of you were alive for this, there was the Civil Rights Act of 1964, which is enacted when Lyndon Johnson was president, which prohibited discrimination based on race, color, religion, sex, and national origin by federal and state governments. So what did it do? It ended discrimination in public places, prohibited a discrimination in employment based on race, colors, religion, sex, national origin, and it established the Equal Employment Opportunity Commission to investigate and prosecute cases of employment discrimination. Then we come to presidential executive orders, and there are many of them. Every president issues an executive order or many executive orders when he becomes president or when he becomes president. President Johnson issued Executive Order 11246, prohibiting employment discrimination based on race, color, religion, and national origin by those organizations receiving federal contracts and subcontracts. President Johnson established a policy of affirmative action designed to ensure equal opportunities for minorities who had been shut out of many workplaces due to discriminatory hiring practices. It required federal contractors to engage in affirmative action in their own workplaces. I might just point out about 11246, that executive order stayed in effect from the mid-60s, around 1966, until January 19th, 2025, when the current president revoked it. Now coming out of the Supreme Court, we have some decisions. First of all, Brown versus Topeka Board of Education, which most of you know about. It ended racial segregation in the nation's public school systems. Next, we had a case some 20 plus years after that, known as the Regents of the University of California versus Bakke, where a majority of judges ruled that race could be considered as one factor among many in admissions decisions, but not the sole or controlling factor. And then we have Grutter versus Bollinger. There in 2003, the Supreme Court ruled that the use of race as one factor among many in a wholly holistic admissions process was permissible, provided it was narrowly tailored to achieve a diverse student body. With that background, we get to what is the current law from the Supreme Court, decided in 2023, Students for Fair Admissions versus Harvard. There, the question, you can all see it, whether the admissions systems used by Harvard and the University of North Carolina were lawful under the Equal Protection Clause. There, the court decided that those admissions programs violated the Equal Protection Clause of the 14th Amendment. This Supreme Court case provides much of the foundation for the executive orders issued by President Trump. The majority ruled because Harvard and UNC's admissions programs lack sufficiently focused and measurable objectives warranting the use of race, unavoidably employ race in a negative manner, involve racial stereotyping, and lack meaningful endpoints, those admissions programs cannot be reconciled with the guarantees of the equal protection. Remember now, I read the Equal Protection Clause a little earlier. Some of you may have forgotten it, but it stated very clearly that you couldn't abuse the rights of any, I'm going to read it right here. No state shall deny any person within its jurisdiction the equal protection of the laws. Any person there, the equal protection of the laws. So we will find out how the Trump administration is defining any person. Before we get to that, though, the dissent in the Students for Fair Admissions case stated the philosophy of three of the Supreme Court justices. The Equal Protection Clause of the 14th Amendment enshrines a guarantee of racial equality. The court long ago concluded that this guarantee can be enforced through race-conscious means in a society that is not and never has been color blind. And there the justices stated who dissented. Unfortunately, that is not the law of the land. That is just the dissenting opinion. So it is now time at this point to look at the executive orders directly impacting African Americans and racial justice. And we're going to take a look at 5. We're going to examine each one of those so that you can make a determination as to whether they are impacting and how they're impacting racial justice. We're going to give you the reasons, or at least the presumed reasons, for the Trump administration's executive orders. We're going to talk about what the executive orders do and don't do, and what does the future hold. I put this slide in so I could get a drink of water. All right. Executive Order number 14151, ending radical and wasteful government DEI programs and preferencing. Terminates all discriminatory programs including illegal DEI and diversity, equity, inclusion, and accessibility mandates in the federal government. This was all of these, everything in this order was directed at the federal sector of the government. What's important about that first clause is that the order rescinds an executive order issued by President Biden that required federal agencies to submit equity action plans outlining how they were going to achieve DEIA. So when he says he's terminating all discriminatory programs, he is basically saying that the government will no longer carry out these equity action plans, which was his intent. The order 14151 goes beyond that. It directs a review of all existing federal employment practices, union contracts, training policies to make sure they're complying with this order. And lastly, this executive order, in part, federal employment practices shall reward individual initiative, skills, performance, and hard work, and shall not consider DEI or DEIA goals or requirements. So in a word, what this executive order does is it removes any diversity, equity programs from the federal government. What was always important for all of your lifetimes when you went to the federal government has been removed by that order as far as diversity is concerned. Then he issued on the same day or the next day, Executive Order 170, reforming the federal hiring process and restoring merit to government services. And I should have said this before, as we look at these executive orders, what's on the screen are just partial readings of each executive order. We couldn't put it all on the screen or we would have been here all day. So these are just little excerpts that I've lifted out of the executive orders. But this one is directed at hiring. Federal hiring practices are broken, insular, and outdated. They no longer focus on merit, practical skill, and dedication to our Constitution. Federal hiring should not be based on impermissible factors such as one's commitment to illegal racial discrimination under the guise of equity. A federal hiring plan shall prevent the hiring of individuals based on their race, sex, or religion, and prevent the hiring of individuals who are unwilling to defend the Constitution or to faithfully serve the executive branch. So you know what this executive order does. The first executive order removed diversity from the federal government. This executive order removes diversity if you want to get a job with the federal government in the hiring process. The next executive order, 173, including ending illegal discrimination and restoring merit-based opportunity. Executive Order 14173 revokes Executive Order 11246, which I already told you about. That was Lyndon Johnson's executive order requiring affirmative action in all contractors. The next part of President Trump's executive order is the following. The Office of Federal Contract Compliance Programs shall immediately cease promoting diversity, holding federal contractors and subcontractors responsible for taking affirmative action, and C, allowing or encouraging federal contractors and subcontractors to engage in workforce balancing based on race, color, sex, sexual preference, religion, or national origin. So the whole point of this executive order is to remove any question of diversity with anyone who contracts with the federal government or any subcontractor, which would require the contractor or the subcontractor to affirmatively reach out to have a diversity program. So the president did a thorough job in removing diversity from the federal government, those who wanted to work in the federal government or those who wanted to contract with the federal government. Then we come to Executive Order 14253, which is entitled Restoring Truth and Sanity to American History. This order was issued in March of this year, and it was designed to let people know that the exhibits in the Smithsonian Institution that had been put there prior to January 20th of this year were not of the liking of the current administration. The widespread effort to rewrite history deepens societal divides and fosters a sense of national shame, disregarding the progress America has made in the ideals that continue to inspire millions around the globe. We will restore the Smithsonian Institute to its rightful place as a symbol of inspiration and American greatness. It went on to say, this executive order, that we want to determine whether since January 1, 2020, public monuments, memorials, statues, markers, or similar properties within the Department of Interior's jurisdiction have been removed or changed to perpetuate a false reconstruction of American history. So what this executive order really means is that the current administration is going to decide what happened historically as far as this country is going to concerned, what exhibits are appropriate and not appropriate, what statutes are appropriate and not appropriate. I think one writer said this order is an attempt to sanitize U.S. history. The final executive order is a little overly legalistic, but it's important. They begin by saying what disparate impact liability is. And it is a legal theory holding the differences in outcomes among races, sexes, or similar groups indicate unlawful discrimination even without proof of discriminatory intent or policies. This is a legal theory that holds employers liable for policies that disproportionately affect protected groups, even without intentional discrimination. The administration's reasons, one of them is that disparate impact liability has hindered businesses from making hiring and other employment decisions based on merit and skill, their needs or the needs of their customers, because of the specter of such a process might lead to disparate outcomes. So what he's saying is, I don't want the U.S. Attorney's Office to be involved with any cases where there is an effort to prove disparate impact liability. It is the policy of the United States to eliminate the use of disparate impact liability to the maximum degree possible. It is likely, very assured, that there will be litigation regarding this executive order. So, trying to put my head in the head of the administration, I wanted to just try and think what the reasons are that they are against DEI. And one, I think there's a belief that DEI creates prejudicial hostility and conflict because you're looking at race and gender and age and other such things, and that can bring hostility and conflict. Secondly, DEI hiring based on demographics rather than ability and qualifications is a threat to the meritocracy. The country, the administration believes, was in decline because there were too many DEI hires working in government and business. Illegal DEI unfairly disadvantages white people, particularly white men. And DEI is a civil rights violation. Efforts to address historical inequities have resulted in unfair treatment for individuals who are part of a majority group. There you go, where they're saying the people in the majority are getting unfair treatment. Critics of DEI view society as a zero-sum game. And what that is helping one group brings another down. So those are the likely reasons why the administration has issued these orders. Let's take a look at what they do. This is sort of a score sheet that the Legal Defense Fund put together. I didn't do it, they did it. But one, terminate DEI offices and programs in the federal government. That's been done. Repeal prior executive orders designed to ensure equal opportunity. That's been done. Bring about a reduction of Black and other racial minorities in federal government. Target affirmative action and DEI programs at companies that do business with the federal government. Terminate equity-related grants and contracts. Colleges and universities get grants, and that's what they have tried to do in some areas. and challenge programs of publicly traded companies, large nonprofits, philanthropic foundations designed to advance equity, including by threatening legal action with the obvious goal of chilling their programs. So that's what they do. Now, what don't they do? First, it's important to remember that equal opportunity and anti-discrimination obligations are a part of the Constitution. And we've looked at some of those provisions. There are other provisions. So if an executive order runs up against the Constitution of the United States, it is likely going to be held null and void. The other is that the executive orders do not halt programs codified by statute that are designed to remedy ongoing discrimination. So EEOs, as I said at the beginning, they represent the policy of the administration, but they do not have the force of law beyond the federal government. The EEO, the executive order in the federal government is absolute because the chief executive officer of the federal government is the president. But anything that happens outside of the federal government is open to the for further analysis. What does the future hold? Federal government will not support diversity, equity, and inclusion efforts in the foreseeable future. Will de-emphasize the historical contributions of African Americans and other minorities. The federal courts will not allow race to be future, and private industry will continue to scrutinize and potentially use well thought out DEI plans. I'm not sure whether I said it when we first went through definitions, but you can, the biggest issue with DEI is not what it is how it is implemented and carried out. If it is carried out in the right way, it may be able to continue to be a program. Private industry, in my judgment, is going to continue to do what is in their best financial interest. What's the early reading on some of the executive orders issued by the president, especially in the business side? Organizations that eliminated DEI programs report widespread morale issues. Companies that cut DEI programs are losing employees, especially women, Black professionals, and other underrepresented groups. And lastly, without DEI initiatives, companies are struggling to attract diverse talent. And that comes from Forbes' website from a survey done in August of this year. So that has at least about 8 months of evidence for that survey. What does the future hold for racial justice? And that is the question which everyone in this room must come to an answer. Americans must decide whether we can be a nation of diverse and inclusive people, or whether we will let our biases tear us apart. Clearly, what underrides some of this stuff is bias. Whether we can learn from our history of discrimination and violent acts against minority populations, whether the courts will stand firm in preserving the republic. A survey taken at the beginning of the year showed that Americans were roughly split along party lines on the subject of DEI, with 49% of the people surveyed the first week of March saying DEI should be eliminated, and 48% saying it should continue. So the country is split on how it feels about much of what you have heard. So the floor is open for your questions, your comments, your analysis, if we have time.
I have a question. Microphone. Hold on just a second.
Oh, Nolan, that was wonderful, and thank you very much. I was wondering, in the discussion of the minorities, we're discussing American Indians, we're discussing Asian Americans, and all kinds of other groups as well. Is that correct?
We have deliberately not broadened our definitions to include other minorities, except in one or two slides that I may have mentioned. There is so much out there with regard to other minorities, women, people with disabilities. You could go on and on, that we would have been here a lot longer than you would have liked to have been here.
But in essence, though, that does include those people. They are being relegated to the same situation.
Some of the executive orders are different. Some of them can be fit in under the executive orders that I read. Certainly, if under disparate impact, you could have disparate impact liability and have a community of Asians who were impacted under a disparate impact liability theory. So that could apply to any group, not even a minority. It could be a group. But other executive orders were directed at certain minority groups, and I deliberately emphasize race for this program.
Well, there are several races.
There's plenty. We can always broaden the definition. Absolutely, I don't disagree with that.
Not very swift foot.
I think that if I understood from some conversations earlier that you have a lot of expertise about Philadelphia's government in terms of this issue. So Philadelphia government, what kind of freedom does a city government have to do to carry out ongoing programs of affirmative action and DEI, and yet at the same time deal with threats from the federal government that we're going to defund this, we're going to defund that unless you toe the line?
I think you've answered your own question, that to the extent that a city wants to do certain things, it is potentially, and I'm going to use my words very carefully, it is potentially risking a lot of funding, which it is getting from the federal government. And all of the cities, I would think, are risking some of their programs involving the federal government if they want to continue to have active DEI programs. We've seen that as well with colleges and universities where they wanted to continue their program, and there have been in some instances potential threats to lose your funding programs or grants if you don't comply with the orders. So it's a situation where you probably have to take each case and review it to see what is the right thing to do.
Jim.
So many of those executive orders are assertions which are taken as statements of fact, but indeed they're not statements of fact. They're just simply assertions. What can be done about that?
Those are the policies of the President of the United States, and he can have any policy that he wants to have, and he can enforce it to the extent of all those who report to him. There are certainly differences of opinion as to whether or not those policies are appropriate or factual.
I had a question.
Yes.
Is this one on?
Yes.
Yeah, okay. I was just curious, when you talked about the federal employees, has there been a study that shows the data on what the percentage of Black workers and white workers and other diversity are in the government? Can we see the data on that? I mean, kind of along with what Jim was saying. In other words, what is the percentage of Black workers in the federal government?
It's an excellent question. I have seen articles that talk about that. I did not focus on the percentages. I think most people would want to see what's the difference between numbers of, for example, Black people in the federal government today and a year ago, and whether you could attribute it to diversity issues or whether it's performance issues or some other issues. But it hasn't been, I have not done that analysis.
Can a less discriminatory Supreme Court have some impact on these executive orders?
The Supreme Court can and will decide what it thinks is correct under the Constitution. The Supreme Court, and I'm not a Supreme Court scholar, has taken a view that the Constitution is colorblind. And so when you have various programs, college, admission to college processes, that the Constitution is colorblind, the Supreme Court has said you cannot use race as anything in the admissions process. You must try and come to a good admissions policy which is colorblind. And that is different than when 40 years ago you had people who were being kept out of college because of color. But their position is today that that Constitution is colorblind.
The Department of Education, majority of their employees were African Americans. He has taken people who were well qualified and fired them. Particularly in the armed forces, the generals have been fired, and the librarian, who is very well qualified, has been fired. I don't know about Dr. Bunch at the Smithsonian, but he probably is next.
Thank you so much.
More next year.
There's a hand up over there, Susan. Okay, okay.